Appeals, Division 1 is now in session.
Thank you. Please be seated.
Thank you.
Good morning.
Good morning.
We are here for oral arguments in case number IC20-0033, Dirani versus Oreganos. Ma'am, did I say your last name correctly?
Yes, correct.
So a couple of housekeeping items before we get started. Normally, we would invite, when you present your argument, for you to stand at this podium. But because of the times that we're in, we'll invite you to just stay seated at the table you're at throughout argument. You are wearing your masks now. You're welcome to wear them throughout the argument. If you would like to remove them when you present your argument, you're free to do so. We are distanced from you, and we're distanced from each other as well, and so we have our masks off just to be able to communicate with you a little bit better. These proceedings are being video and audio recorded and live streamed, and so when you begin your argument, we'd ask you to just state your name and who you represent, so we have that on the record. Now, each side has 20 minutes to present your argument. Ma'am, you may be able to see on that podium, there's a clock there, and it keeps track of your time.
Yes.
If you need to lean over to try to see that clock at any time, you're welcome to. We also have the time up here. Now, the way that this works is because you are the appellant, you will argue first, and then Mr. Lundmark will go second. If you would like to save some of your time to then offer a rebuttal argument, you're welcome to do so. If you want to tell me now, I'd like to save 5 minutes for rebuttal, I'll help you keep track of that time. If you just want to play it and see how it goes, that's fine as well. But each of you only have 20 minutes to argue. Now keep in mind that we've conferenced the case this morning. We're familiar with the briefs and the record. And so keep that in mind as you argue. Also, when each of you argue, you won't be interrupted by the other. The panel of judges may have a couple of questions for you. And so there may be a time where you're arguing and we say, just a moment, I have a question for you on that. And so if that comes, we hope that won't fluster you, but just expect it if we have some questions. Okay, with that in mind, Mr. Ronnie, you
Yes.
can begin.
Okay. I'm here, Your Honors, appeal in this case on my own to explain to you again my situation about my health since that incident happened to me. So my health is getting worse, and I'm under care many doctors now, from pain management to rheumatologist to psychiatrist, therapist, primary doctors, pain management doctors, to see what I can do to get a relief from the pain I'm getting on a daily basis since that incident happened to me. So I have been suffering for 6 years now. And I get to the point now where the new pain management I'm seeing, they cannot perform on me some kind of injections to see if I can get any relief. Now, I got injured since 2014, negligence from the employee, dropping that heavy commercial umbrella on my back and my neck and on my spine, and since then my health started changing completely. And now, Your Honor, I'm disabled because of that, and I'm getting worse. I cannot use my hands like I used to. I have neuropathy, many issues, many illness now. Plus, before I forget, because sometimes I get the brain fog, it triggered for me fibromyalgia in my body. And now I have degenerative discs. And now the insurance I'm on access, they refusing, denying any MRIs, any treatment, they won't pay for it. So I'm asking the court here, who's gonna pay for my treatment and I'm getting worse? And now my insurance is denying that. And I have a letter with me, which I sent a while back, the Access Insurance sent me a letter asking where did injury happen and how did it happen. So they see my record and say why they have to pay for workers' comp injury. And in the meanwhile, I'm the one who's the victim now here. I'm suffering, I'm not getting the right to treatment, and since the beginning, Your Honor, I didn't get the right to treatment from the workers' insurance comp. When I was under Dr. Jeffrey Scott, every time they order he ordered like a procedure or any treatment, the insurance will delay it 10, 15 days. They say, oh, we gotta give approval. In my opinion, Your Honor, when you're injured like that, this injury has to be treated right away. That's why I got worse, because I wasn't treated well from the beginning. So now I have a problem with my hands, I have more degenerative disc, and I have a report too from a chiropractor too. So, Your Honor, I wanted to submit no evidence, but the court didn't let me. But now with me, I have letters from the doctors. I'm under their care, and if you will to let me get you more evidence and more reports, I'm willing to do that if you let me.
So,
Mr. Ron,
Yes.
Mr. Rani, our review here is only of what was admitted during your proceedings before the ALJ, the administrative law judge. We cannot consider new evidence. So
But now I have,
It does
I'm
not
under
matter.
a lot of care of doctors, Your Honor.
I get that, ma'am, but all we can do is review what was done before the ALJ. So that's the only thing that you're welcome to talk about anything you want, and we want to
Okay.
hear you talk about whatever you want. But I just want you to understand that your time is better spent focusing on what errors or what mistakes were made by the administrative law judge rather than talk about new evidence you
Okay,
wish to
so
present.
Your Honor, when I hired Mr. Tom Whitley to represent me, he told me he's gonna get me treatment first so I can get a relief, maybe yes, maybe no. And I want to explain to you the new pain management now too. I want to mention that so you have an idea. They can perform some kind of injection in my neck. He said maybe it will work, maybe it not. And if it doesn't work, I'm going to live my life like this, the way you see me. There's no other thing. It's a permanent impairment. There's nothing they can do other than that. And there's no surgery, nothing could do it. So my argument here, Mr. Whitley won the case for me, and the judge, Judge Marmore, she gave me the award in favor of me. When Mr. Todd on the other side, the defendant, I'm sorry, sometimes I have to pause, appealed the case, they go in by Dr. Leo, which is not my doctor. He only saw me twice in 4 years. He doesn't know what I'm going through every day. He said I recovered. I didn't recover, my honor, from my injury. I'm still suffering until now, 6 years, and I became disabled. So I'd like to know, why did the judge reverse her decision after me winning the case? And Mr. Whitley told me I'm suffering physically and emotionally from this injury. And I said, how I'm supposed to make my living? He said, later, I will try to get you a lifetime income so you can make your, I can go on with my life. Now, 6 years I didn't work. I cannot go back to work because my work is in the food industry. I'm not supposed to lift more than 5-10 pounds. Now my hands are getting worse, and I have a specialist who's working on that too. So, Your Honor, I want you to judge here my case and let me know what I'm supposed to do with my life. The lady behind me sitting here, she's the one who took me in her house. I couldn't pay any rent anymore. I was going to be on the street. I asked the lawyer, he said, yeah, you could be on the street. What are we going to do? So thank God for her. I knew her. She took me. She's Mother Teresa. She took me in her house. Otherwise, I would be homeless on the street. So, Your Honor, this is me now sitting here. And like I told you, if you need more evidence, I have everything here. You can read like I said, I mentioned that again, you can read the doctor's, letters, what they say. And like I said, I became disabled. So.
Let me explain a little bit about this process. And first, I want to tell you, I am so sorry that
Yeah,
you were
thank you.
injured.
Thank you.
in the administrative law portion of your case, you presented evidence to that judge. You remember that?
Yes,
Okay, so you present evidence and that judge makes a decision about what she or he thinks the evidence supports, okay? When you get to this level of court, we don't look at the evidence. What we look at is the procedure, and we don't reweigh the evidence. We look at what went on. Is it supported, the decision made by that judge that you appeared in front of? Is it supported in the record that was made below? We don't take new information, and I know you've got a lot of information with you that
Yes.
you'd love for us to look at, but that's not our job. So I just want you to understand, what we are looking at is the proceeding that's already taken place and where you go from here. So if you'd like to address any of the proceedings and what you think are defects in the proceedings, we would love to hear that.
okay, Your Honor, my point here, I'm the victim here, and I got injured. It's not like it's a joke or something. I got injured, and I'm the victim here. Nobody is suffering in my place. This is me. This is the injury happened, and it's true. So I'd like you to ask you how I'm gonna get. This is my point. How I'm gonna get the treatment to feel a little bit better from my pain? How I'm gonna go on with my life like this? This is a point here. I'm the victim. I got injured by negligence from another employee and from a heavy, large umbrella. And based on that umbrella, the employer, he replaced the whole place with permanent tents. And they removed all that. It's a dangerous hazard, the way they were replaced and the way they were putting those umbrellas over there. Anybody could be injured by those umbrellas and they can be hurt. Look at for me now, my life is ruined. I was a healthy person before. I had no problem with my health. I was working like 12, 13 hours a day, happy, going. Since that, my life is ruined now. So we gotta consider that. For me, this is something real we're talking about. I became disabled, otherwise I could be working now. I wouldn't be suffering. So please, Your Honors, I'm here to get some justice here, some help from you, and how I'm gonna go on with my life physically, my health, my financial problems. We gotta consider all that. It's not fair for an injured person to go through what I went and just like nothing happened. So please, I'd like you to consider this matter very seriously. I'm not here to just, for fun. I'm explaining my situation and what's happening with me. That's what I can tell you.
Thank you, ma'am. So you've used about 10 and a half minutes, so you have about 9.5 minutes after Mr. Lundmark argues. If
Yeah.
you'd like to offer additional.
Yeah, and like
Okay.
I mentioned before, I like to mention it again, the insurance is denying all MRIs, all the treatment, and now I've got to work with the doctor and see what can we do? What can we do in this situation? How I'm going to get there? And like I said, maybe it's going to help, maybe not, and now we see who's going to cover the cost of this treatment. I have no money to pay for these all these treatments. And like I said, I became disabled. I cannot work anymore. We got to consider that.
Okay, thank you.
Thank you.
Mr. Lundmark.
Thank you, Your Honor. May it please the court and Ms. Dirani. My name is Todd Lundmark, and I represent the respondents, Oreganos and Republic Indemnity. On the threshold issue of whether the award before you was reasonably supported by the evidence, the testimony given by Dr. Leo Kahn, a board-certified neurologist, certainly supports the denial of Ms. Dirani's petition to reopen. Dr. Kahn actually saw the applicant twice, as Ms. Dirani just noted. He saw her the first time in February of 2015. Her symptoms at that point included pain involving both sides of her upper back. She complained of headaches and complete right arm numbness. She had had a thoracic MRI scan at that point in August 2014. Both Dr. Khan and the radiologist reported that it was unremarkable. Dr. Khan thought that her physical exam was likewise within normal limits, and he opined that in this accident, which had happened 9 months earlier, she had received 9 months of care, that she had likely suffered a contusion from which she had recovered. The other thing to note about the history is
Was there any competing information back in the 2015? I know there was, the one that's on issue now, there was competing opinions. Was there a competing opinion in 2015?
No, and to the contrary, Mr. Ronnie mentioned something about Dr. Jeffrey Scott a moment ago. He was her attending physician initially. She got his name from an attorney, and we know Dr. Scott pretty well. He was the one who recommended the neurology consult, and when he received Dr. Khan's report, he told the rehab nurse on May 26, 2015, he deferred to Dr. Khan. So when this claim was closed, it was closed with no controversy and no request for hearing. In 2018, she petitioned to reopen her claim. We thought it was a good thing to have Dr. Khan reevaluate her, and he did. In February of 2019, he had a good baseline for comparison. Now her symptoms had escalated, and they included tinnitus, dizziness, irritable bowel syndrome, fatigue, heart palpitations, brain fog, and so forth. Dr. Khan advised that the exam was frankly non-organic. He could not come up with a physiologic explanation for her complaints. She had had another thoracic MRI scan at that point. It was done on April 19, 2017. The radiologist compared it to the first one. It was unchanged. It was unremarkable. Dr. Khan told us that he could not identify any new condition for Ms. Dirani for which her claim should be reopened. And ultimately, it was his opinion that Judge Marmore accepted. So on this record, we
But on
have
the first
good
time, the
support.
judge didn't accept it, correct?
Yes.
Okay. So, and as I read the record, there was the statement from her physician about the void or dark mark on the MRI that could have been a ligament tear. So that, if you guys had appealed from that decision and not sought reconsideration, we'd be affirming. There would be evidence in the record to support that, wouldn't we?
We would not be here. That's
Okay.
correct.
But you guys didn't appeal, so you sought reconsideration. And what changed? And I get that the judge can look at it again and change her mind, but it's unusual in the cases that I've seen to have this situation. So what changed from day one to day two that we can explain to Mr. Ronnie why things have changed?
You know, and I can speak personally, having done this work for so many years, it is unusual for an ALJ to reverse her opinion on review. So we get an award, we may or may not like it. If we don't like it, we have the opportunity to request review. Oftentimes we have a really good legal issue that brings us here. A lot of times it's just a matter of our being unhappy with how the judge resolved the evidence.
So when we look at ARS 23-943 and the last sentence of subsection A says failure to respond, discussing a decision upon review, will not be deemed an admission against interest. It's not that the court simply disregarded the first ruling. What, in your memorandum below, what do you see as the linchpin of why she switched course 180 degrees?
You know, the Judge Marmore gave us her reason for changing her original award. We basically said, will you please take another look at this case? We don't think you made the right call. And to your point, Judge Moore, I've done that many, many times over the years. Morris, and I've gotten nowhere with it. But on this occasion, the judge agreed. One of the arguments we made was Dr. Warden's interpretation of the first thoracic MRI scan was completely inconsistent with the interpretation of all the other doctors who had looked at it. And that was the key point for us. She was making observations.
When you say all the other doctors, just walk me through that. That would be her original physician from the 2015?
Dr. Scott, the radiologist, Dr. Khan, and then subsequently she saw some other doctors, including, you've seen reference to Dr. Ali Aragi.
Right.
And he had the same interpretation of that study. So basically, we appealed to the judge and we said, please take another look at this. This is a standalone opinion. It's inconsistent with the opinions of everybody else. And she reversed herself on review. She had that discretion. And in her decision upon review, she referenced that very point in her decision on review. I think that was the reason why she changed her award on review. It's supported by the evidence. Ms. Dirani did file a letter that you could interpret as a request for review. I don't think the judge acknowledged it, but she indeed reopened the record. By that I mean she reviewed the record again. As I read the letter that Ms. Dirani wrote, it was basically along the lines of what we're hearing today, which is she has a permanent impairment. And of course, Judge Marmor resolved that by accepting Dr. Khan's opinions, indicating that she has no permanent impairment. So the award is supported by this record, and I think the best explanation for why the judge reversed herself was, I asked her to take another look at the case. She did. That's her opportunity. If she had said no, I'm sticking with my original award, which was a bit unusual. She reopened the claim, she closed it, she found no permanent impairment, she granted copious supportive care. We asked her to take another look at it, she did, and we're glad she did. We think she made the right call on review.
Why should we, and I think I know the answer to this, but I'm going to make you tell me, why should we defer to that second opinion? In other words, we have a judge who's now issued two, I think, and I don't mean this in a derogatory sense, but two completely inconsistent decisions. I think you'd acknowledge that, right?
Well, she reversed herself on review.
Her decision one is completely inconsistent with decision two. There's no way to say, well, there was a different evidence or additional evidence. This was same evidence. She said A on decision one and B on decision two. Correct?
That's exactly what the request for review process is intended to do.
I get that, but so I'm not trying to trap you. I just want to make sure we're talking on the same thing. So two inconsistent decisions, yes.
But after decision number two, the question remains the same. Are we deferring to the fact finding of the ALJ at that point?
Yes, and that's the question. Why should I defer to ALJs when the ALJ has flip-flopped?
You know, it'd be the same reason that we do.
There's no new evidence.
I think the explanation is we defer to the judges for the same reason. They've heard all the evidence. They've spent more time. They've heard the claimant testify. It's within their discretion to resolve those medical conflicts.
Am I still bound? I mean, normally I'm bound. The Supreme Court and the statutes have told me, if there's any evidence in the record to support the decision, I have to affirm it. In other words, the three of us don't have any choice, right?
That's correct.
Okay. Is there any case law specifically or statute specifically addressing this decision where the judge has issued decision one, which is A, and decision two, which is B, and I have to now say I'm ignoring decision one and I have to still follow decision two?
Nothing that I think is directly on your point. We have all the cases over the years that talk about deferring to the fact finding of the ALJ unless we see evidence that it was arbitrary and capricious, which I think is perhaps the concern of the court now. And my argument is it isn't. She had a good basis for reversing and backing down and agreeing with Dr. Khan's opinions for the reasons that I mentioned earlier.
I would agree with, I'm sorry, go ahead.
Go ahead.
I would agree with you completely, and the record supports that there was numerous opinions and numerous facts from which the ALJ could reach the decision that she ultimately reached. So in the normal case, this is not a close case, but it just strikes me as something very odd when you have a situation where the ALJ has not heard new evidence. Your memorandum doesn't really point out anything she overlooked other than the fact she just didn't weigh it properly the first time. So isn't that different?
Yeah.
You know, all I can say is from my standpoint as a practitioner, it's gratifying when a judge will do what she did, to take another look at the case, to reweigh the evidence and decide what makes the most sense on this evidence. It doesn't happen very often. It's nice when it does. It happened here.
Isn't that the whole point of subsection F of the statute 23-943? Why would we have a review process if the judge wasn't allowed to change their mind? That doesn't make sense, does it?
Well, I agree with you completely.
Okay. So,
Otherwise, we could just dispense with the review process and go straight to the court.
and so, given that it is authorized by statute, we must accept her decision if it's supported in the record, even if it's 180 degrees different than her original decision. Is that your take?
You know, this isn't something that Ms. Dirani briefed, and I grant that she's not an attorney. My best answer is, I think we're still bound by an arbitrary and capricious standard. I think if the judge offers no explanation for changing the award, maybe we have something to talk about, but Judge Marmore did in this case. She gave us her reasons, and I think she adopted my argument on review.
Can I say something?
You can once Mr. Lundmark
Yes,
finishes
okay.
his argument.
Yeah.
then you can.
I guess I should say in closing, since we're here with Ms. Dirani.
Yes.
I thought Dr. Khan said it best when he testified, and he said he did not doubt that she is suffering, that she has discomfort. He could not attribute her complaints to an incident that involved a simple contusion, in his opinion. Maybe we have some good explanation for why she's in such discomfort, but we do not think it's this injury. Thank you.
Okay. All right, Mr. Ronnie, you
Yeah.
have about 8 more minutes. You can
Yes.
take up to 8 more minutes. And
The first time I saw Dr. Khan, that was in 2000, the first time, 2015, I believe. And he examined me, well, like a regular exam, lift your arm, lift your, let me check your knees, let me check your, and I told him, you know what, I can't even sense my shoulder anymore, even no sensation, no everything. I explained to him what's going on with me. The second, when I saw him last, only 2 visits, he admitted in his own words that you really did change. He told me, you have a change over here, and I see weakness in you more. I couldn't walk like a cross in my legs. He said, yeah, I see weakness more in you, and you did really change. And now 2 doctors, specialists, Your Honor. The first, Dr. Scott, I just want to explain about Dr. Scott. He looked at me in my own eyes and he told me, you cannot live your life like that. But he didn't give me any explanation why I'm gonna. When I asked him, he had no explanation. The new pain management doctor, now he's telling me too, you cannot live your life like that. If these 2 doctors, they telling me you cannot live your life, that means they know something, what's going on in there. Dr. Catherine Warden, Your Honor, you should look into Dr. Catherine. She's a professor in musculature, measures. That's her own specialty. And she examined me, not like Dr. Leo, lift your hand. I stayed in her office for 2 hours with my brother. She need him as a witness, he could be here. For 2 hours, she examined me, and she knew exactly what was going on with me. When he hit me by the umbrella, it was like someone stabbed me with a knife. I screamed. So the ligament got tear. I have nerve damage. She told me there is no cure for you. No surgery will do it. Only treatment. Maybe you'll get better, maybe not. And even now, I'm not seeing Dr. Catherine now. I'm going by a new doctor in pain management. They referred me to him from Dr. Catherine. This is a new pain man referred from Dr. Catherine to this new pain management. He told me last week, we cannot try those injections on you. Maybe it will work, maybe not. If it's not going to work, you cannot live your life like that. What does this mean from a doctor saying you cannot live your life like that? They know I'm disabled, so there's nothing there that can work for me. Now, and still I'm insisting the insurance is not going to cover those treatments, and he's ordering more MRIs. I have another report, I'm going to say that and insisting from my chiropractor. He took x-rays for me. He said something is wrong in your upper region. There is really something wrong. When they get the thoracic spine, I'm going to look at it too. I'm taking many opinions. Now the insurance denied it. But what I'm asking, Your Honor, these doctors, they saying to me, you cannot live your life like this. What does this mean? That means that an injury happened and it did change my health and I became disabled. So this is the argument. Another thing I wanna, like you said, thank you, from Judge Marmore. I'm really disappointed. How can she adopted Dr. Catherine Warden after testifying for me? And I have the letter from Mr. Whitley saying she testified excellent and explained what's happening with your health. How can we go, how can I say it? How we can take this away from us and just look at Dr. Liu Khan, who only saw me once, and he admitted I have weakness in my legs, and he said, you really did change. Something really did change you. How we gonna go away from this? I'm really disappointed, really, I'm sorry to say, with the judge for reversing her decision, and now I'm stuck. Like I said, I'm the victim and I'm stuck, no treatment.
Mr. Dirani, the problem that we have up here is that the legislature, by law, has told us that if there's any evidence in the record that would support the lower judge's decision, then we have to affirm it. And so we have right now evidence in that record of one doctor who said that it was a problem. Let me finish, ma'am.
Yes.
One doctor who said that there may be an injury that was caused by that is causing these problems, and more than one doctor, but at least one doctor who said, no, there was no injury that's causing these problems today. So we can't just ignore what the legislature, what the statute, what the law tells us to do. And so if there's any evidence in that record to support it, we have to affirm. We have to say, I'm sorry. So do you understand the situation we're in up here?
Your Honor, if I'm going to the neurologist, Dr. Liu, to see what's going on with me. And he admitted, he said, you did change and you have weakness, and I can see that. As a doctor, why didn't he order for me more tests, more MRIs, more things to see what's going on with me at this time? Huh?
Yeah. But there was also 3 years from 2015 to
He's not my doctor. He's not treating me. You know what I mean? He only saw me with, like I said, that I lift your leg. And like I said, he admitted he sees weakness in me and changes. As a doctor, when he sees a patient like this, he's got to order more tests. He's got to order more, further information to see what's going on, why he's seeing the weakness now in me, why this is happening to me, why this is going on with me, not just to give, she recovered. How did he know I recovered and I'm disabled person? It's logically, I'm talking logically. How can I recover and I'm disabled now? This is a question we gotta address. How did I recover and I'm still suffering? I can't use my hands. I cannot feel my shoulder, a stiffness. I wake up with pain. I go to bed with pain. Nothing, even the medication is not working for me. And if we look at medical things, they tell you trauma like this will trigger fibromyalgia, will trigger all kind of pain in your body. You will get worse, and that's what happened to me, because you gotta treat this from the beginning the right way, which it did not happen to me. And like I mentioned again, 2 doctors, they said you can live your life like that, and this is true. It's been 6 years, and I'm getting worse. And the older I'm gonna get worse. So now my situation, you wanna leave me like this without a treatment, and I'm the victim here, and I see this is not fair. This is not fair. To an injured person live the life like this, disabled and not get a treatment, and the insurance refusing to pay for this and that. For me, this is not fair, Your Honor. That's all I can say, and you can rule.
Thank you, Ms.
Thank you.
Dirani. Let me say that we are sorry for the injuries that you sustained and for the
Thank you very
challenges
much.
that you face. And to your neighbor, we
Thank you
tip
very
our
much.
hat and we're grateful you have a neighbor a friend
Yes.
that's taken you
Yes,
in and helped you out,
really, thank you very
which is
much.
just wonderful.
Yeah,
So at this point, we will take the matter under advisement. What that means is we don't issue a ruling here while you're sitting in court. We'll discuss the case further
Yes.
amongst the judges. We'll issue a written ruling, and then that will be distributed sometime in the future.
Yeah,
once
sure.
that decision has been reached,
And
okay?
would you let me admit more medical reports?
We would love to in a perfect world, but our hands are tied. We're limited to only
Okay.
look at what was submitted to us.
So
And so
when
we have everything
Okay.
that we're allowed to look at.
But
already.
are you willing in the future, when you study the case again, are you willing to take more evidence?
We cannot.
We can't.
We cannot.
We cannot, okay,
Yeah,
so,
the law doesn't allow us.
okay,
So we're limited on what the administrative law judge had
okay,
before her. We're limited to that, and we have all of that.
Okay.
So we have reviewed it, and we'll continue to discuss the case.
to discuss.
Then we'll issue a written ruling that will be
Okay.
distributed, okay?
Thank you very much for
Okay.
listening to me and for being here with me. Thank
And
you
best
very
of
much.
luck to you.
Appreciate it. Thank you very
Okay,
much.
we are adjourned.
Appreciate it.